item that they're selling or the product that they are selling, doesn't comply with local building codes, do they? That's the question I'm
Oh,
asking.
I bet they don't. But the point of the article is that the lack of compliance is immaterial. It's the illustration I gave where 0.00035
Mhm.
of 1% were blew off the house, where there wasn't a material defect. The point that the author is making is driving 8 to 9,000 nails in a roof, perfection just cannot be the standard. And so, if it doesn't have enough nails or it's off more than a half inch, then sure, there's a problem. But his point is that it doesn't that a small variance of the code like a half inch doesn't matter.
Well, look, I don't practice, construction laws, not my bailiwick. I did go to law school, did learn something about the implied warranty of merchantability and the guarantee that when you sell a product or offer a product that it's free from defect. So I am a little sort of taken aback or surprised to hear anyone say that a product that they are selling or promoting or offering doesn't exactly comply or may not comply with local codes and regulations and may not be free from defects. And I get your point about, well, it has to be material, but I would think that building codes and local ordinances mean something. The standard is there for a reason, right? I don't think that local municipalities and county governments, they pass ordinances just as dicta or something that is just symbolic, right? So there's a reason that those regulations are there. Would you agree, disagree with
No,
that?
I completely agree. And the point is that it is material compliance. That's really the point of the article is that the departure is so small, and that it is a material compliance. He's kind of using a little bit of hyperbole or kind of an exceptional title to catch the reader's attention. But as you read it, he gives a really nice illustration about the driving of roofing nails and how exacting that can be, so that you don't drive it too deep, don't leave it sticking up, and it's not slanted. But the his point is that it is material compliance with the code, even though it's not perfect.
Okay. And so sticking with your point about material compliance, and I kind of want to sort of piggyback on something that the chairman just mentioned, an example that he gave. Maybe that's a situation where someone is not physically hurt or the structure of the home has not been, compromised. But when an individual wants to sell that home, as you well know, you have to divulge any and all defects, with the property. And so let's just say that defect, causes a precipitous drop in the value of the home. Maybe it drops by $50,000, $100,000. I would think that for the homeowner, they would feel that they've been impacted, or that's a material impact, at least to their bottom line, if they're trying to sell that home, right?
I would think that yes, I would agree with you. But if it's an immaterial defect, that hypothetical really wouldn't
Not
apply.
immaterial to the homeowner. If
I'm,
the house has taken, if the home's value has plummeted by 50 to hundred thousand
yeah,
dollars,
I guess that I would respectfully disagree that if it's an immaterial defect, not in somebody's mind, but in objective ways, that the
I would think that
there
the
would that
appraisal would be objective, right? If someone has to appraise the home, taking into account the defect, and there's a precipitous drop of $100,000 in the property's value, I think most homeowners would view that as very material.
I don't think it would be. I'm objecting to the hypothetical is what I'm trying to do.
Okay.
I'm saying that the appraiser, if he found an immaterial defect like that, at max would put the amount that it costs to correct it. It wouldn't be, let's just say it's the stairs to the basement and there's 13 steps. Those kind of things, if it's a little high, they could be taken apart and shaved off. We would be talking about thousands of dollars, but not 100,000.
Okay.
And I mean, there is a place at which finality is craved by the business world. And 8 years is the year. And this materiality is where we're trying to avoid. I'll back up and say that illustration that I gave you about the 372 houses by the builder spent $700,000 in attorney's fees for something where 300 shingles out of 852,000 blew off. There's got to be some sort of, I said attorneys, it was attorneys and engineers, but there's got to be some protection for this inconsequential type of a thing.
Okay, well, I agree with you that certainly, builders should have some finality, but just know the consumer or the homeowner wants finality as well. And typically for them, they believe that finality happens, once the purchase of that home has been consummated. But I'm with you. Thank you.
Thank you.
Senator from Charleston.
Are you aware of this language in the bill that's proposed to be changed? Has that been lifted from any other state?
I'm informed that it came with one word change from Florida.
Okay. And so do you know have you looked at any of the case law in Florida, whether the Florida courts have construed this language?
No, sir, I have not.
That would be helpful to know how they did that, because our courts would look to what other courts have done in other states.
Agreed.
But you're not aware.
No,
you just
I'm
don't
not.
know.
No.
Thank you.
Thank you, sir.
Thank you.
Sean Cranford. Morning. If you'll raise your right hand. You swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you, sir.
Thank you, Senator. Senators, Mr. Chair, I'm Sean Cranford. I'm a lawyer here in Columbia. My entire practice is a representation of homeowners associations and community associations in South Carolina. I am here on behalf today of the Community Associations Institute, which is CAI. A few factual numbers. There are about 1.4 million homeowners living in HOAs and COAs in South Carolina. Just under 600,000 homes, 7,500 HOAs. That number is growing by the day because of the obligations to form associations. CAI, its members, are opposed to 244 as drafted, specifically Section 6. We recognize the difficulties in construction. We have developer members, contractor members. We recognize the difficulties with conformance. Our concern is this will ultimately remove the baseline obligations of the building code. It will lower industry standards, and candidly, the homeowners will bear the burden of repair. The questions that were just asked, at the end of the day, definition of material, the building code is material. It is adopted. We have concerns that those standards are lowered. It lowers construction quality. We see that almost 2% population growth, the fastest growing state in the country, coastal South Carolina, the fastest growing areas. Home builders are not slowing down. Affordable housing is still there relative to the term affordability. At the end of the day, if this exception in this bill passes, the homeowner will bear the burden. All of these defects that I see from my clients are latent. They don't expose themselves in similar nature to personal injury type matters. They're water intrusion, stability, structural integrity. And like the layer of an onion, you have so many layers to your homes, to your condominiums, that they don't expose themselves year over year. It oftentimes takes more than 8 years. The exception currently in place allows us to point to the building code, the baseline minimum standard, as an exception to those issues. Taking that exception away, I think ultimately leads to cost for homeowners. I think it leads to increased cost. In the case of condominiums, I have several associations now that have special assessments. Special assessments create funding issues. Fannie and Freddie guidelines limit funding in special assessment cases. And ultimately, lead to structural integrity and life safety issues. There are condominiums similar to Surfside in Florida and coastal South Carolina as we sit here today. They are condemned. The issues were not prevalent. They went too long, and their owners have no ability to pay and fund these repairs. Period. End of story. There is nowhere to go back to the age of it. 8 years is a short statute of repose. It's one of the shortest in the country. This exception gives ability for owners to seek recourse. They are the ones that have an expectation. They are the ones that have safety. They are the ones spending their money. Everyone else along the line, contractors, engineers, architects, myself, profit from their expenditure. And 8 years, candidly, is limited when they expose themselves. This exception would limit that and make it a hard stop 8 years. Quite candidly, I think you see life safety issues. I think you see increased assessments and fees, housing costs, and I think, as was said the prior week, you're going to see homeowners that are stuck in their homes. They cannot get funding. From a life safety issue, there will be condominiums, high rises and medium rise condominiums that will not be able to get funding. They have to disclose for any Fannie and Freddie guidelines, known defects. Are they being repaired and replaced? And how are they being funded? Special assessments are the only way to do it. You have a limited pot of money. You assess your owners. That discourages purchases and lending. On top of that, the defects discourage lending. So you now have owners stuck in their home, their condominium, their project that they can't sell. Ultimately, that leads to non-repair and the issues that we're seeing in on the coast now, and heaven forbid what we've seen, life safety issues around the country. So happy to answer any questions that y'all may have.
It seems to me that your argument really is to the statute of repose itself.
No, it's not. It's not. I think that certainly standing up here on behalf of my homeowner clients and not from a construction world, my association clients, sure, everyone would be better off. 8 years is okay. The exception.
You said that people don't know within 8 years.
I think oftentimes they do. This exception and the exception, the statute of repose has the exception now, gross negligence, fraud, et cetera, which can be evidenced by a violation of the building code.
And that's part of the issue, right? Is that right now we're saying that is you're essentially telling the jury that they defrauded you.
So, Senator, I think from the baseline and to some of the comments that were there in your day-to-day cases, my office represents several hundred associations. Within the last few weeks, I've had folks call about a swimming pool issue, a roofing issue, carpet that was installed improperly. The response is fix it. It's not a litigated matter. It doesn't rise to the level of litigating and fighting. Fix it, it's maintenance, and move on. In the cases that you see litigated, the ones I'm aware of, the ones I've seen, there are substantial issues across the board that haven't presented themselves till later and need to be addressed. So the day-to-day
is the statute of repose.
No, I think the problem still remains the exception, because you can point to, without resultant damage, defining significant and material damage, that these items have impacted the structural integrity of the building.
But I mean, effectively, doesn't the existing exceptions follow the rule?
I'm not sure I understand your question.
Well, I mean, you got a statute of repose. We've got a limit,
Right.
but if the exception to the limit is any building code violation, regardless of whether there's any damage or not.
So
right? You're always going to be able to find
I
a building
don't.
code violation, aren't you?
You shouldn't be. I think it's difficult not to have one. I think that any reasonable jurist, I believe, and I've not participated, that there are cases where the judges have pointed out that the building codes you're referencing, similar to Mr. Barnes, don't tie into the damage and the issue that you're seeking recovery for. There is a causal relationship between the two now. But what this is going to do, and what my concern is you are eliminating the baseline need for the building code. I have client associations. I'm aware of developers that hold projects for 10 to 20 years now. One client that never has to turn over control. So in perpetuity, a developer holds this to 8 years and is out the door. More importantly, a developer disregards the building code, builds thousands of homes a year, rolls the dice. We're going to get to 8 years on a handful of them, and we'll worry about the one or two that we don't.
Your clients' buildings don't have to be inspected by building officials before people go in there?
So building officials in South Carolina, one, have statutory immunity. Two, they are looking for truly life safety issues in the turn or electrical issues, ingress, egress issues. They are not there to inspect the installation of the windows, the flashing, the installation
Should we
of.
change that? Should they be responsible for that, for looking at those things? I mean, how does for some of these things, how even would a builder know that there's been a mistake?
So my understanding, again, limited, is your general contractor who makes 10 to 20%. And again, I want to be very clear. I think the large majority of contractors and homes and buildings constructed, I mean, the overwhelming majority, 90+%, are done well and substantially perform, and there are no issues that you would ever know about. But they have an obligation for oversight. They should have someone on site inspecting at different stages. And what's happening, and what my concern is, not what's happening, my concern is, you eliminate this building code exception, it pulls that obligation away. We can look at it and see where we are in 8 years. This, in my opinion, and my concern, creates a hard 8-year stop. To go back to your initial question, yes, I think that is too short and would be across the country, but that's the law.
Create a hard 8-year stop if there's physical material resultant damage.
The question of what is physical, what is material, and what is resultant, the definition and question there, we now know that what the violation of the building code is. We can, with experts, point to this was the issue, this is what caused that issue. We have a law and a baseline of the building code where physical issue and resultant, and I would quite candidly take the position and would be happy to talk to my clients. Every property built has a physical violation. The way the siding's hung, the installation of the roof. So you end up in a similar situation, whereas the building code violation is a direct point. This is what it was. This is the baseline standard, and this is the issue that we're addressing, whether it's window installation, life safety issues, and my belief to Senator Adams, yes, that would be an immaterial violation of the building code for a CO2 alarm, but the personal injury may not overcome that because it's been more than 8 years. That's my concern, is at the end of the day, the owner is the one that suffers. And I do think there's a hard stop, and I would imagine a review, the number of terribly old cases well outside of the statute of repose from 05 or now is minimal.
Well, I mean, how does a building official miss a CO2 detector in the wrong spot?
What are there 6,000-7,000 houses under construction in Horry County today, and how many building codes? I mean,
Well, then that's a problem with building officials.
well,
I
I think they do a yeoman's job.
Yeah, but I mean, you told me that, all right, they don't look for most stuff. They just look for the life-saving issues. I mean, they're not going to miss that.
And I'm not a
And
building official.
if they miss that, then there's a real problem with the building officials. And if it is missed and there hasn't been any damage, just fix the damn thing. Right?
No,
There's
I
not gonna
agree.
be a
And
lawsuit over that.
that is of the several hundred associations I work with, that's our recommendation. This isn't matter. Fix it. The big issues are what my concern are. The large scale issues, the high rise condominiums, the multifamily, where it doesn't result, and you now created a hard 8-year stop effectively.
Well, what
and
should the stop be?
You go to sell.
What should the stop be? Should there be a stop?
Yeah, absolutely.
What should it be?
I mean,
8 years isn't enough. What should it be?
if I could wave the wand and do it, most states in the country are between 10 and 15 years. I'm sure there are folks that disagree. And again, I don't have the magic button. What I see and what my opinion and CAI's opinion, and I've heard from homeowners, I want to be at work today, but I'm the one that lives in Columbia. We have these issues that have arisen. We wouldn't be able to address it from the upstate on Kiowee to the coast. We had these issues, and our belief is this would have stopped it, and we would have had to assess our homeowners members thousands, if not tens of thousands of dollars, and it's uncollectible.
Senator from Green, can you give me an example in what you've dealt with personally, or that you know of, that claims it would have been barred if this becomes, if the
Claims that would have
that you wouldn't have been able to bring
claims that would have been barred.
that you would not have brought.
Day to day, I don't live in the defect world. I have worked with it and know of it. Claims without resulting damage, and where I've seen issues on the coast, and where I've had conversations with clients of age wise, you have roof issues that have been impacted in a hurricane. You see the damage afterwards. It's been too many years. It's not resultant. It wasn't a building code violation. You weren't aware of it. Here, you can point to the building code. You're aware of it. You've inspected it. Candidly, I think if this passes, I'm going to have to go to my clients and say, it's 7 years, you are breaching your fiduciary duty not to do a full inspection of your home, of your buildings, because I'm worried this is a hard stop.
I just disagree with you that it's a hard stop.
Yeah.
I mean, if you
Well, I think the definition, my concern is the definition, the building code is defined. The definition of significant, resultant, et cetera, is not. Personal injury, certainly. And I think that exception is pretty easy to be made.
Okay, so you represent homeowners associations
For some crazy reason. Yes, sir, Senator.
in this type of litigation?
No, I have participated in this type of litigation in spots. My practice is a representation of homeowners associations, condo associations in South Carolina. General counsel, insurance issues.
And you represent them from
A corporate
the
counsel.
beginning, from the time that they are developing plans, engineering plans?
It depends. Not on the construction side.
Not on the construction.
I will typically work with them after transition from the developer, which is where I see.
Do you have any idea if how many of the clients you've worked with have hired any independent engineers or experts to evaluate compliance with the building codes, or are you relying, because these are big communities,
Correct.
a lot of money at stake. Do they ever hire their own consultants to evaluate whether the building code what during construction is being complied with,
Industry-
as opposed to just relying on the local officials who have immunity? And
Industry standard and our recommendation for associations, both single family and condo, they hire and work with reserve specialists, folks that look at the capital repair and replacement of their components. So painting the buildings, re-roofing it under the assumption that it's
I'm talking
constructed
about
correctly.
construction, though. I mean, are they relying just upon the local building code?
These are all homeowners that purchase a home after it's built.
Okay, these aren't
Sometimes
condos, these are
both condos, but a condo owner buys after construction, and they're working under the auspices that it was built correctly, and most are. So there's no need. None of my clients, I can say with certainty, none of my clients have done an investigation of building code and building component issues without a need. The reason my clients are doing it is they have systemic leaks.
It's only when
A problem's arisen. I think if going forward, that'll be my recommendation to my clients is
To do
that
what?
at 6 years to retain an engineer and insurer because of the concern with this. And that would be the recommendation from our industry.
Thank you.
Senator from Berkeley.
Thank you, Mr. Chairman. So this might not be a question for you. I'm going to kind of feed off of Senator from Charleston. So on the construction side of it, does your company or contractors hire independent inspectors?
So that would not, Senator, that I represent the homeowner.
Okay.
99% are after the developer is gone. As I said, I've got 4 or 5 that are still under the control of
I'll
developers.
save that question for
Yes, sir.
somebody else that might come up. So in regard also, I want to make sure I'm clarified on the CO2 detectors. It's not, from my understanding, talking to the contractors and builders, it's not that they are not following code. That's why if you walk into all these new tract homes, the CO2 is on the ceiling. It's not that they're not following code. The code is just not telling them where to put the CO2. And it's a combination alarm, whether it's a fire and the CO2, and they just stick it on the ceiling. And I've had them tell me, we know it's not going to work because CO2, if it ever gets that high, it's too late anyways. Right. So, and to me, you would think as a contractor, if you know that is a possible issue, why not add another CO2 at the 18 inches if that's what's needed? But that's for somebody else. But I appreciate it. Thank you.
Sir.
Yeah, I'm curious. What if we just extend their statute of repose to 10 or 15 years and eliminate all the exceptions?
Not a professional, don't live in the construction world every day, but I would think yes. I mean, if you went to 15 years, Sean Cranford and I would consult with CAI and our lobby. Speaking on behalf of Sean Cranford, absolutely.
Well, I would prefer that the homeowners associations be against me.
Well, I can, well, but I think I understand that, but this one, and part of the reason I didn't want to be here, of the homeowners in our organization are concerned with this. I understand
It
that.
seems to, like I am persuaded by the argument that there's got to be an end.
Absolutely.
And it seems like right now under the current law, there's no end. But I understand what you're saying, that sometimes things pop up later on. I mean, I'm persuaded by that as well. But at some point, it's got to stop.
I agree. I think 8 years would be too soon. If you went to 15 years, I think most people would realize it. I also think it's hyperbole to say that there's not an end. The number of construction litigation cases that you see outside of probably a 15 year period are few and far between. Do they happen? Absolutely. But again, my office represents several 100,000 homes through our associations, and we're not aware of it outside of that 13 to 14 years.
15 years sounds like a long time to me.
And I'm not the one to say, would Sean Cranford say that? I think that works. But I think, if it was a hard stop, 15 years, yeah, absolutely.
I mean, it seems to me that the existing law, especially if it allows for an exception for any type of a building code violation, it seems to me that it could swallow the rule most of the time.
And I think the thing that concerns me from my practice and practicality is you don't see the exception on minor issues. You see the exception with major issues: water intrusion, structural integrity, roof integrity. As I said, the clients I represent, hey, we've got a carpet issue, 10 years old, replace it and move on. Folks are practical. The way Repose is written, this exception, especially as drafted, my concern is it benefits contractors, professionals, insurance folks, and it is a detriment to the homeowner, the only one expending money. And I agree there should be a stop at some point.
Well, it certainly benefits the contractors in the context of it's giving them some more rigidity, some more definitive idea. But what we're talking about here is an exception to you got
Absolutely.
8 years.
Yeah.
This gives you more than 8 years in these situations. And it would still, and this is where I think I would agree with the senator from Greenville. I disagree with your characterization. It's a hard stop because there are exceptions in the language. But this is giving additional time frame to the consumers, to the homeowners, to the HOAs even. It gives more time beyond the 8 years, but it gives more. I mean, like from a contract, and I don't know anything about it, but I would think it's got to be similar to any business. You got to have some understanding of what the finality is going to be. And like these folks, I mean, they've got to purchase insurance, liability insurance for whatever they do. If the insurers are in a position of having to insure for liability indefinitely, that's going to have to affect.
So the insurers, and again, stepping a little out, don't insure indefinitely. They're for claims periods and for that claim. And then the thing that I have some concern with is rigidity and finality. The building code is the minimum standard to which a structure could be built. I would argue and say that none of us in this room would buy a home or structure built to the basic standard of the building code. So that gives you a definition. The technical violations and something that doesn't impact the structure, folks don't litigate it. It is when there's a large standing. This opens up to an unknown, in my opinion. I know there's a disagreement. Our concern is it allows for a harder 8 years for someone who's not building to the minimum standard that is established and a homeowner buys it. That's the concern. And ultimately, I think it's a life safety issue.
It just seems to me that if we're not meeting the minimum standard, that's a problem. I agree with you. Okay?
Agree 100%.
But if we're not meeting the minimum standard, we ought to find out about that before 15 years later.
I think,
If that's an issue with building officials, if inspectors need to do a better job, but I mean, if we haven't met the minimum standard, I shouldn't have to wait 10, 12, 15 years to find that out so that I can fix it.
But as a latent, and I think the day-to-day practical issues, you fix them, you move on, just as you and I would in our home. The issue with building and structures, if the breach of the building code is in the framing, the flashing, it's underneath 2, 3, 4 layers of exterior siding. And we all ride by these large scale developments and they look great because the siding's there, the brick front look perfect. It takes time for it to appear. I mean, it truly is latent. And again, I think it's important to say large majority of home builders, of contractors, overwhelming, do it the right way and make repairs when they're noticed. Large scale, I'm not so sure.
Senator from Richland.
Thank you, Mr. Chairman. Do you think it would help if we were to flesh out the definition of material a little more?
Yeah, I think defining those terms. I mean, as a hard stop with a reasonable time period makes sense, defining that term. But I think defining that, if the building code is not the most reasonable, lowest standard, what is? I mean, that's the concern. And you look at the large scale, it's a roll of the dice. We can build 3,000 houses and 2 of them pop up within 8 years. We've got away with 2,900 of them and lower standards.
Okay, thank you.
Thank you, sir.
Thank y'all.
Mr. John Hayes, John, I know you're here and you testified last week. I'm wondering, why don't we have you come up and maybe Mr. Barnes, you come on back up and let's have you two just tell us, you both do this for a living. Tell us kind of you've heard some testimony. Tell us the whys and kind of get closer to the microphone so we can hear, because we're going to want to hear you.
Sure. If I could say a few things and then I'll pass it over to Mr. Barnes, if you don't mind. A couple of things I want to address, and I might skip around because we kind of skipped around at this point. First off, there's nothing immaterial or trivial about a violation of the building code. Swear myself in.
Well, let's see. Swore you in last week, still under oath.
Okay.
All right. Go.
All right. There's nothing immaterial or trivial about a violation of the building code. The building code is for the life and safety and welfare of South Carolina citizens. A violation of the building code after 8 years is a life, welfare, safety issue. Now, if you want to sue the builder for something else past 8 years, that's not a life, safety, or violation of the building code. You can't, because the statute of repose stops you. A great example was given by Mr. Adams in regard to this carbon monoxide, and also a good example of the stairs. I had a example of, you go get tires put on your car, and they only put 4 lug nuts on a wheel that takes 5 lug nuts. why do you have to wait until the wheel comes off before you're able to go against the person who put it on there incorrectly in the first place? That's kind of the same thing. A violation of the building code, we shouldn't wait until there's property damage, which is harmful, or personal injury, which is harmful. If it's done incorrectly, it needs to be fixed, whether it's 6 years, 10 years, 12 years, or 15 years. Now, Mr. Massey had a very good question, like, well, why are we having these building codes violations? Why aren't the building officials catching it? Because they can't. Unless South Carolina is going to pay these building code officials, or these counties pay these building code officials to sit on that job site from 8 a.m. in the morning until 5 p.m. every day, they're not going to catch it because it's all hidden. It's latent. It's behind walls. It's through wires. It's on roofs. They don't get to be able to do that. There's just no way. Now, whose job is it to make sure it follows the building code? The contractor. That's the sole job of the general contractor, is to make sure that it does the building code. That's all they do. I don't think I've ever seen a general contractor out there slinging a hammer, putting on shingles, or doing anything. They get paid their 20% or whatever their percentage is, and building the houses to make sure it conforms to the building code. That is their sole job. That and making sure that people show up for work. That is their sole job. Now, as far as the exception, everybody calls it an exception. I just look at it as part of the current statute of repose. But you said, Mr. Senator Massey, that it swallows the statute of repose. It doesn't. It just does it if there's a building code violation, which again is a life safety. What's that? Yes, there's plenty of things that happen in a building. You can't sue them because they put up the wrong color, because wrong color.
Is there ever not a building code violation?
Yeah, there's a lot of times. You can build a house without having. Everybody get a little. I think there's some confusion. We're not saying that a house has to be perfect or that a building has to be perfect. There's no such thing. There's no person that's perfect. But the building code does not address every little single thing. The building code is addressing life safety issues, such as roof shingles, such as the way windows are installed, the way a foundation that holds up a house is done. And those things do not present themselves until a long time afterwards. They're latent defects. And sometimes they might not present themselves at all because, as Senator Johnson said, nobody's fallen down the stairs in 9 years, but he's still got to pay money to fix it. And that's not his fault. It's not his fault his building doesn't have the right rise on the stairs, and that he has to now disclose it and come out of his pocket thousands and maybe $100,000, $10,000, $2,000, whatever it is. It shouldn't matter because he didn't cause that problem and he didn't build that house. All he did was pay good money for that house or building to be built according to the building code or be passed on to him and within the building code. So we're not talking about trivial things here. I think I looked it up in earlier, and it said that, another example, I'll hit one more thing. Senator Adams called it carbon monoxide. Under his example, 9 years later, you find out the carbon monoxide detectors weren't put in the right place. Now, the only thing he has in his building, maybe it's a 4-story commercial building, he only has a recourse under the new way it would be set out in this new bill that's being proposed, is to pay for it himself because nobody's died yet. Why should we wait till somebody dies? Why should we wait till there's property damage before something becomes material? And the way the amendment's written, it says it's only material. And it's not a jury's decision about whether it's material or not. It says in the language as drafted, it's only material if there's physical harm or property damage, or personal injury or significant property damage. And that's a problem. No. Well, a jury's gonna have to come up with what significant is. Nobody, I don't even know what significant is. I know what it says in the dictionary, but it's what is significant damage? It might be, I can tell you this, the way it's written right now under Senator Johnson and Senator Adams' scenario, they could not go against the builder. They wouldn't, because there's been no physical a personal injury, and there's been no property damage. So under those two scenarios, if they discover this problem in 9 years, neither Senator Adams or Senator Johnson will be able to go after a builder.
Senator Adams' example, you're not going to file a lawsuit against the builder anyway.
And Senator, if John Hayes had a building that he had built and found out that the carbon monoxide detectors weren't put in the right place 10 years after it's been built, I personally would sue the builder to get the money to fix that problem.
I thought his example was residential, but in any event, why don't you just go to the builder and tell them there's a problem? They're gonna fix it. Now, if they don't, if they don't, then maybe you've got a problem. But I mean, if you go to a builder and say, "Hey, look, this carbon monoxide detector's in the wrong," they're going to fix the thing.
I wouldn't have a career in construction defect litigation if that was the case, honestly, because they have the opportunity. Because there's a law that y'all passed called the South Carolina Notice and Opportunity to Cure Act, and that's where we have to give the contractors the opportunity to come in, look at what we've alleged, and they can do three things after they look at what we allege they did wrong. They can offer to fix it, they can tell us to go pound sand, or they can pay the money to fix it. So they already have that ability. I'm happy to answer any questions or.
Anybody? Senator from Richland.
Mr. Hayes, so the senator from Edgefield, he mentioned that, it appears this could be a jury question as far as the issue of, if a violation is material or not. But the way, again, just looking at the proposed language, you can tell me if you agree or disagree, and this is based on your experience as well. But it seems to me that may not necessarily be a jury question, right? Because the attorney has to, I'm quite sure there'd be a motion for summary
It's not a
judgment.
jury question.
And I'm quite sure defense counsel will argue vigorously that there's either no harm to the person, or they will argue that there's no evidence of significant damage to the performance of the building or its system. So would that, in your estimation, be a question for the jury? Would that be more so a question of law that a judge would have to decide? So in other words, we're not even certain that with this language, a homeowner could get their case to a jury on that question.
That is correct, because it's not material unless there's physical, if there's significant property damage or personal injury. So all the defense attorney's got to do is stand up and say, well, that might be these stairs or this carbon monoxide, the exact scenario that these two senators painted. He can say, that sounds good, Mr. Hayes, and I understand what you're saying, but I'm looking at this statute and it says it's to be material that has to be personal injury or property damage, and you've got neither yet. You're just telling me it wasn't done right and that they should have to pay to have it fixed. So that is correct. And there's one other thing that I do want to, I know, when my colleague, Mr. Cranford, was up here, but I do litigate these cases and I do try these cases. And I can tell you this, juries don't give away free money over just little stupid technicalities. They just don't do it. They'll laugh you out of the courthouse if you bring, I hate to say, a stupid case or a stupid technicality in front of them. It's got to have some meat to it. It's got to have something that the jury believes in. Juries don't give free money to other people. They just don't.
Okay. Thank you.
Thanks, sir. Mr. Barnes, you want
Yes, please.
to give us your side of the story?
Yeah, I'll be really brief. Let me address the jury question issue. The bill says a violation is considered material only if it exists within a completed building, structure, or facility, which has resulted in physical harm to a person or significant damage to the performance of a building. Significant is not a concrete term. Significant to what, when we were talking earlier about the $100,000 issue, what's significant to Senator Walker may not be significant to me. The court, with our summary judgment standard, with just all inferences being given in favor of the plaintiff, that is never going to be granted summary judgment. That is going to trial. That's just I've made my point. Mr. Cranford made repeatedly a statement that our statute of repose is short. Let me read you the statutes of repose from people around us. Florida, 7 years. Georgia, 8 years. North Carolina, 6 years. Virginia, 5 years. Alabama, 7 years. We're 8 years. We're not short. In fact, North Carolina has had a 6-year statute of repose with no gross negligence exception since I started practicing CD law in North Carolina in the mid-90s. And you can get summary judgment in North Carolina on their statute of repose, but it certainly doesn't happen here, and it's not even worth trying. Another point that was made that I want to address has to do with perfection. Perfection is not achievable. It's just when the standard is so exacting that a roof and nail being a half-inch off is perfection, it is just not achievable. And so an immaterial, by definition, is one that has not hurt the performance of the building. I do agree that the exception swallows the rule. That's why we don't move for summary judgment on the statute of repose.
Senator from Charleston.
Going to your point about the significant damage to the building, the performance. So I want to go back to Senator Johnson's example of the stairs. And so, because I hear what you're saying about the nail and it can't be perfected, but at the same time, for his scenario with the staircase, if it was a couple inches off and 10 years later he had to, because it then became a problem, he had to pull those stairs out and repair them. I mean, at that point, that would be a damage or a performance to the building, correct?
I would think that, yes. I would think that an expert would say that if they're 2 inches off, an expert would say that's a life safety issue. I was talking about if they're 1/8 of an inch off. But if it's 2 inches off, we're all accustomed to walking stairs that comply with the code, and we don't even think about it. So
if we leave this in, and as we've noted, the majority of builders and contractors probably do the right thing. But then would you not agree that if you building thousands of homes, just going, and then even to Mr. Hayes' point where the contractor can't know what all is going on, they'd have to sit out there all day, or the code, the building code people. And so to that point, would that not then, I mean, why would a builder then worry about if they know that his stairs, we're off a few inches, and maybe it is 2 inches, and they're like, well, it won't materially affect the building, but we know there's a defect, but we can't be sued anyway, so let's just keep going because we got a deadline to build these other buildings. I mean, do you not see that as an issue? Because part of the reason I believe that it's in there is to deter and to follow the building code. But it's almost like saying, well, everybody's speeding, so we shouldn't have a speed limit, and so why follow it? And that's, so do you not agree that that's in there to, one, make sure that people are following the building code, and two, to deter them from sort of doing it the quick way, but also being what I would call reckless?
I think that the purpose of the building code is to require compliance. What we're talking about here is immaterial, insignificant things that don't matter. A 2-inch change in the rise of a step would be very material. And particularly a large tract builder that had a 2-inch wide, a 2-inch above the building code, he would be the subject of a class action and be exposed for tens of millions.
So would you agree that, so are you saying that there are things in the building code that are immaterial, that are not necessary, that are currently in our building code?
I'm not saying that they're not necessary. I think that the building code as it's written is fine, although it does get adjusted.
But it should be followed.
It should be followed, but you can't expect perfection. And that's what this proposed bill does, is it allows for the roofing nail that's a 1/2 inch off, but that the performance is unaffected.
Okay.
I'm going to have both of y'all because it's kind of to both of y'all. I'm a real estate attorney. I don't sue people, but I do a lot of closings. And there's a neighborhood in York County, and they built an entire section of homes in the Charleston style homes. And about 10 years in, they realized that someone hadn't bothered to put flashing on part of it, and on one of the flat parts, sticking out where the balcony is, kind of off the side of the home. And not one house had water damage. About 110 houses had water damage. I mean, you could just, it was there. Some had, $500 go up, new flashing. They had gotten, it had been caulked enough that it didn't, and that it didn't have substantial problems. Others, they had rot, mold. You had a host of issues. When you say significant, the mold case is significant. The $500 fixing, let's put flashing up, repaint that side, and boom, we're done, might not rise to that level. But if I'm the homeowner, it's significant to me. It is significant to the HOA because they have to fix all of them. And so I 100% agree with Senator from Edgefield. There has to be an end at some point. You just have to say enough's enough. But when you say something like significant, you're just so limiting, in my opinion, who can qualify. Even in that scenario, you're limiting, this house is significant, this house isn't significant. Well, it's significant to the guy who had to have it fixed and the HOA who had to write a check to have that fixed. I don't know if that's more of a statement or a question, but I just kind of love your feedback, because significant seems to be to me at least, one of the sticking points in this, because we're going to the Supreme Court, right? The Supreme Court's going to define significant, because that's where
Eventually, it's going to have to. I've got a good scenario I'd like to tell you about, which is a real life scenario. So there's a building that I represent down in Horry County, and they put the balconies on not according to the building code. And because of that, some of these balconies began to start pulling away. When the engine, okay. Do you mean to start over again? Okay. When it was noticed that some of these balconies were pulling away, it was we went back and we looked, and we found that the balconies, when installed, did not conform with the code. They presented a life safety measure. All right. So now that HOA, I represent them, is in litigation against the builder to get the money to fix. They've already had to do temporary repairs to them, but to fix those balconies. Now, under the scenario you were talking about, you use flashing, but in 10 years, the people who either fell off the balcony, right? Because that's all that's going to happen. Either fell off the balcony, or the balconies that fell off the building and landed on a car. Under this new bill, they would be able to seek redress against the builder and sue them. But the people who had the defective balconies that were not installed according to the building code and still presented a life safety measure, if nobody had fallen off the building because of them, or these hadn't fallen off the building themselves and caused property damage, they would have no recourse against the builder.
How does that's a bad situation, but how does that not go to the performance of the building? Well, if the balcony's falling off, how does that not go to the performance of the building?
Any violation of the building code goes to the performance of the building. That's what the building code is for the performance of the building. That is exactly what it's there for. It doesn't address everything, but it addresses the life safety issues. And my reading of the new way that this new bill is written is that nothing is material unless there is personal injury or property damage.
But significant damage to the performance of the building. I mean, if the balcony's fallen off, surely that's significant damage to the performance of the building.
It is, but for the balconies that haven't fallen off yet, or somebody hasn't fallen off that particular balcony, it is not significant performance because it hasn't happened. The damage has not occurred yet, but it's still a violation of the building code. And you should still be able to, instead of you having to pay for it yourself, get the person who put them up there the wrong way to build for them, pay for it.
I don't know that I agree with that. I mean, if you see, I mean, if all the balconies are built the same way and one of them starts to pull away and you discover it's because of a building code violation and therefore you then have significant damage to the performance of the building, it's the same problem everywhere else, even if it hasn't materialized yet, right? You know, it's coming. Right.
You and I agree 100% on the same thing. I agree with what you're saying, but what I'm saying is the way that this is written right now does not allow that. I agree 100% with your position and what you're saying. But the way it's written, you will not, if it's past 8 years, you will not be able, except for those particular balconies that have caused personal injury or property damage, you can pursue those, but you could not pursue the ones that had not failed yet, even though they were installed incorrectly.
But then let me ask you this. Is the statute of repose too short?
I don't think it's too short unless you talk about the violation of the building code. I mean, I think that 8 years is fine. If you don't want to sue your builder after 8 years for something that doesn't violate the building code.
Should there ever be a finality date?
You know, Your Honor,
That's never.
no. Well, my position is the only thing in life that's final is death. And what I'm saying is we're not according finality to a lot of other areas. So
I'm okay if your answer is no. I mean,
I think if you built it incorrectly, if you did something incorrectly, you should be held liable for it. Now, we do have, and that's what we get to statute of limitations and the statute of repose. Statute of limitations says if you discover a problem, you better move on it. You can't just sit around and say, well, I discovered it in 2000. I'm going to wait till 2007 to sue. You can't do that. You get 3 years. The statute of repose says it doesn't matter if you know you have a problem or not. You only have 8 years. And that in itself is a problem. So, but I think that the legislators back when they passed it, in their wisdom, realize the severity of a violation of the building code. And that's why they put that language in there saying 8 years unless there's a violation of the building code.
So your position then is that there should be no limit at all if there's a building code violation.
That is correct.
Senator from Richmond, but 1 second. We have 3 minutes and we have a hard stop. Please feel free, but I wanted Mr. Barnes to have a minute to have the last word, so to speak.
I have.
Go ahead.
Shall I go ahead?
You go ahead, Mr. Barnes, and I'll ask my question.
Okay, fine. I'll be super brief on this. Something I wanted to address that was misstated earlier is the idea that a developer can wait 8 years and outlast before turning over the homeowners. The statute already has an exception in 670 that says that the statute of repose may not be asserted as a defense by a person in actual possession or control as owner, tenant, or otherwise. So that's never going to happen. The developer can't just hold on to it and then turn it over in 8 years and be. You can look at it, section 670.
You can come up. We got about a minute. So, Senator Rich, why don't you ask your question? And
you know what? I can talk to Mr. Barnes offline. It's fine. Absolutely.
all right, Senator from Richmond, go ahead and ask your question.
Mr. Barnes, I promise you I'm not picking on you, okay?
Quite all right.
Please know that I value the construction industry. I know that they are very important, to our county, to our state, put a lot of people to work. They help grow the tax base. And so I have an appreciation for what they offer. But my question for you has to do with subsection B. I'm just going to read it very quickly here. The statute as it's currently written. For purposes of subsection A, the violation of a building code of a jurisdiction or political subdivision does not constitute per se fraud, gross negligence, or recklessness. But this type of violation may be admissible as evidence of fraud, negligence, gross negligence, or recklessness. So when I come across the word per se, clearly that means that a violation of the building code in a vacuum, just by itself, that's not sufficient. It has to be something else in addition to the violation, right? The plaintiff's lawyer or the homeowner has to present evidence of, recklessness, some sort of indifference. So with that being the case, why do you think it's necessary that we, amend that part of the statute, or at least the proposed amendment would eliminate a violation of a building code as evidence of gross negligence? Notwithstanding that there may in fact be evidence presented that shows some sort of indifference on the part of the builder.
Yeah, because the immaterial violation shouldn't be left to somebody to determine whether there was gross negligence or recklessness or fraud. Under the current situation, the exception does swallow the rule. And even though it's not mandated that somebody gets summary judgment against you, it is recognized that a violation of the code, even of the most picayune kind, is going to be almost impossible to deal with.
But it says that the statute, as it's currently written, it says, that by itself, a violation of the code, that alone cannot be, that's not enough for something to be, for a violation to constitute gross negligence. There has to be something in addition to the violation of the code, right? Something outrageous, indifference, that has to be shown.
It doesn't say that there's got to be something in addition. What it says is that it's evidence of, and if the jury finds that it's evidence, if the jury is satisfied with it, then it's done. There's not, I guess I respectfully disagree that there's got to be something else. It's evidence of gross negligence.
Well, the statute says, it's, per se, it's not. So it means, intrinsically or just, on its own, it's not sufficient to constitute gross negligence.
No,
Senator, we have to stop. It's now after 11. I apologize. Obviously, we did not get everywhere we wanted to go today. I thank y'all for coming. I am going to meet with the chairman of Judiciary today and try to establish how many times we can move next week. I want to tell all the members of this committee, if you have amendments, you should have them ready by next Thursday. You should start meeting with, and that means you do not call staff Thursday morning and start asking for amendments. You start calling them today and Tuesday. But by next Thursday, you should have your amendments and be ready to discuss the amendments and this bill, because I would like to move this out of this committee by the end of Thursday. But we obviously have to have at least one or not two meetings before that, but I just want to lay that out so everyone understands. Thank y'all. Is there a motion to adjourn? Second, we're moved. Thank you all. Thank y'all. Thank you.